Thank you.
Sorry, just a brief response, if I may try and draw a few things together. In relation to the 1861 Act, I think the continuing reality of automatic sanctions is something tremendously daunting. And I think you heard that earlier in relation to people who are in the front line of delivery, that is, people who are medical and nursing staff. In relation to the sufficiency or otherwise of the Medical Council guidelines, our point, and I think we made it repeatedly, is that in the absence of legislation, they remain guidelines. The legislation will actually give confidence underpinning to that, and also to people in relation to whom the guidelines are not enacted, because that's another side of this argument which is really important. Third question was asked in relation to the range of opinion within the Church of Ireland. The first thing I articulated was the question of real and substantial risk. That would very much be the central position. There would be fluidity, I have to be fair, in relation to a lesser or a greater sympathy regarding suicide and regarding aspects of health. Now, we speak, as I said, as individuals from within the Church. The Church of Ireland needs to make decisions synodically. Within the time frame that we had, this was not possible. We blame nobody for this. We just state that. But what we are saying is trying in some way to represent aspects of thought within the Church of Ireland. And I'd like to thank all of you very much indeed for giving us a hearing. Thank you.
Thank you. Ms. Good.
Thank you. I just wanted to mention, comment on one, the lady deputy over there said about where's the compassion. And as I sat there, I thought maybe in my presentation and talk, seeking for the rights for the mother, it has come across that there is lack of compassion in the Methodist Church for the unborn. And I say forgive me for that, because in my own heart personally, but speaking to many Methodists across this land, nobody is happy fully with this position we take, because we do have compassion, I can assure you, for the unborn, and support all life-saving measures possible. And it's a desperate situation, and I would not want to be in the medical profession to have to make these choices. And it's a very easy seat to take here. So I just simply say it's difficult, and we have compassion. Thank you.
Thank you. Dr. Murrow? No? You okay?
Really is apart from being grateful on behalf of the moderator and myself for being present with this. There is a quality or an ethical principle which has not been mentioned as yet, which I will just leave you with. It is foundational to all the Abrahamic faiths, and that is the principle of hospitality. It is the practice of hospitality which is foundational to the whole ethos of our faiths, particularly manifest within the Middle East, within the Islamic and the Jewish traditions. But it is what is practiced by the mother in her care and love for her child, by the extended family for that mother, by the community for that family, and which historically has lay at the roots of some of the best aspects of what it constitutes Irishness. And I would encourage that whatever legislation may be necessary to be formulated, that principle of hospitality be somehow woven into the fabric of such decision making.
Thank you, Rabbi Lind. Okay, you happy? Dr. Salim?
Well, I would like to say that we cannot give green card to victims of rape that, yes, you can go for abortion, but I would say that psychological problems, likewise physical problems, if considered by medical doctors and then they decide that the only alternative to come out of this situation, then it is abortion, I would say yes to that.
Thank you. And Mr. Nugent?
Okay, I'll answer the question that I was asked about whether I was being prescriptive. I'm not. I'm being the opposite of prescriptive. I'm saying that individual ethical decisions have to be taken by individuals, and that individual ethical decisions about pregnancy have to be taken by the pregnant woman in conjunction and in consultation with her medical team. You may be confused by the point that I was making, is that you as legislators are restrained by the 1983 amendment as interpreted by the Supreme Court in the X case. Now, I wish that wasn't the case. I think you shouldn't be restrained by that. I think you should be able to democratically pass laws based on the needs of Ireland today. But until such time as we get rid of the 1983 amendment, you cannot do that. Finally, with regard to the question of late abortions, if the fetus is viable, the fetus will be delivered as a baby. You know, that's what happens in hospitals. There are cesarean deliveries every day in our hospitals. I mean, let's not invent problems that don't exist. Thank you.
Dr. Jones, sorry, Senator Haynes. Sorry, Senator Haynes.
So he doesn't agree with
Thank you.
X without time
Thank you,
limits.
thank you. Dr. Jones, thank you. Just to finish up, yeah.
Just like to finish by saying I think there's huge confusion out there of terminology. Reading the papers yesterday about abortion, direct abortion, which is the deliberate killing or destruction of human life. And as Father Bartlett has pointed out, the situation where in treating the mother with every possible medical attention, that a child dies. That, in our view, is not abortion. And that has to be clarified because there's confusion there. And could I finish just with these words? We do not need to legislate for abortion to protect women's lives. We do not need to legislate for abortion to satisfy the European Court of Human Rights. In our view, abortion is always morally wrong because it takes a human life. There has to be another way. Thank you very much.
Thank you very much indeed. May I thank all members of our churches for being here this morning and the AIDIS organisations. Can I thank the members for the participation? We'll suspend until 10 to 12. 10 to 12. Thank you. session. Thank you. Is that agreed? Thank you. This is the 9th of our session. I want to welcome you all to our meeting this morning. This is the 9th session that we're meeting in, and of the hearings of the Joint Oireachtas Committee on Health and Children to discuss the implementation of the government decision following the recent publication of the expert group report into matters relating to cases ABC versus Ireland. At each session up to this morning, and including this morning, we have heard very thoughtful, very considered submissions which have been followed by very sensitive engagement and discussion, and this approach has facilitated the hearings which have been constructive and informative. For clarity, I would like to again set out to the background and intended role of which these hearings are playing in this very important discourse. We're here to discuss the implementation of the government decision following the recent publication of the expert group report into matters relating to cases ABC versus Ireland by way of legislation and regulation within the parameters of our current constitutional perimeters. And government has stated that the aim of its action on this matter is to ensure clarity and legal certainty in relation to the process for the determination of whether a termination of pregnancy is permissible in cases where there is a real and substantial risk to the life as opposed to the health of a woman as well as that pregnancy. In doing so, we must ensure that we take full account of Article 43(3) of our Constitution. And I would again like to thank everybody for participating in the session, that we will continue our engagement in a very calm and a very tolerant, respectful way, respecting the various opinions and views which we've heard and which we'll hear. And this morning, in this session, I'm very pleased to welcome from the Pro-Life campaign, Ms. Caroline Sims, Dr. Barry Kiley, from Youth Defence, Dr. Owen DeFrita and Dr. Sean O'Donnell, from Family and Life, Mr. Patrick Carr and Mr. David Manley, and from the Iron Institute, Ms. Breda O'Brien and Ms. Maria Steen. You're all very welcome to me this morning, and thank you for being here and for making yourselves available. And I'm sorry you're kind of hidden in the corner. My apologies for that. If you want to move over more, maybe it might be more helpful if you want to move over more, maybe, so that you can be seen, if that would be more convenient. I think it would be, you know, just to help us in the facilitation of the broadcasting as well of the proceedings. Before we commence, can I just remind members, witnesses and members in the public gallery and media regarding mobile phones that they could be turned off, please. And can I just, before we commence, remind witnesses and members regarding the position on privilege. Witnesses are protected by absolute privilege in respect of the evidence you're to give to the committee. However, if you're directed by the committee to cease giving evidence in relation to a particular matter and you continue to do so, you are entitled thereafter only to qualified privilege in respect of your evidence. You are directed that only evidence to be given with the city matters to be given, and you're asked to respect the parliamentary practice to the effect that where possible you should not criticise nor make charges against any person or persons or entity by name in such a way as to make him or her identifiable, and members are reminded of the long-standing parliamentary practice or long-standing ruling of the chair to the effect that members should not comment on, criticise or make charges against either a person outside the House or an official either by name in such a way as to make him or her identifiable. With that, I want to welcome again our witnesses and thank them again for coming in. And I want to welcome Ms. Caroline Sims from the Pro-Life campaign. You're all right, that's okay. They have a habit of falling this week, so, but thank you for coming in, and you may begin, and you have up to 7 minutes. Thank you.
Thank you, members of the committee and members of the Oireachtas. It's a great privilege and an honour to be allowed. It's a great privilege and an honour. Is this better? It's a great privilege and. Oh, does it?
No, if you just do
Stop the talk.
push. No, the actual seat itself.
Oh, sorry. Oh, yes, thank you very much. I thought it was going to come so I could sit. Thank you very much.
No, you're all right.
Thank you very much indeed.
As you know.
Thank you, yeah. And thank you very much for the invitation. It is a great privilege and an honour to be allowed to contribute to your discussions on this very, very important matter. I've been listening very closely on the internet, as a lot of other people have been over the last few days at the proceedings. And if anything has become absolutely clear, it's that the government's argument has been completely demolished, that suicidality can be addressed by abortion.
Use the microphone. If you
Are
could
we
maybe
having
move
problems
down.
with sound? Shall I start again?
If you maybe move down one seat, maybe.
I'll change seats.
Yeah, just for the presentation.
Yeah. Okay?
Yeah, no problem.
No, go ahead. Go ahead.
All right, okay. Can I ask the members of the House, is it better if I sit or is it better if I stand? Sit. Thank
you.
Okay.
Okay.
Having completed the formalities then, can I just say the testimony that we've heard over the last 2 days has completely demolished any argument that suicidality can be addressed by abortion, even during crisis pregnancy. Professor David Ferguson in the British Journal of Psychiatry has said there is no evidence that suggests that abortion reduces the mental health risks of unwanted or mistimed pregnancy. That's referred to on page 6 of our written submission. That being the case then, why are the legislators even contemplating passing legislation against the medical evidence? The answer is because they believe they have to because of the X case, and they're being told that they must because of what the ABC decision of the European Court has required. I'll come back to that in a moment. What would be the impact of passing this legislation? Firstly, psychiatrists would be asked to propose a procedure for which there is no psychiatric justification. Obstetricians would be asked to terminate the lives of healthy baby in physically healthy women, and legislators would have violated the most basic human right for a reason which cannot be justified. Society would perceive that the right to life for the unborn is not really that important, and we're not really serious about protecting it. After all, it can be violated on an entirely irrational and unjustifiable basis. After a time, this becomes received wisdom, and that is the end of the culture of life and the beginning of the culture of abortion. If you surrender the principle of the right to life of the unborn, that sends a message to society, which in turn produces a cultural change. Then other cultural questions emerge. What other rights will you overwhelm when their subjects are not very important? Some people refer to this as the slippery slope argument. Whatever you call it, it is certain that ideas like these have real consequences. Why do so many of the doctors who have addressed this committee want legislation? The pro-choice advocates, some of whom frequent this chamber, understand the possibilities for their agenda and have welcomed the proposed legislation as an important first step and a beginning. But most of the doctors who have come here want something quite different. They want to know, in the words of the master of the maternity hospital, that I will not go to jail, and that they are free to make appropriate clinical judgments for their patients. The reasons for this fear are somewhat puzzling. It is not sufficient to hinder the doctors in their practice of medicine, as they've all said that they have never refused an intervention or withheld any treatment because of any fear of the law. The Irish Medical Council has not received any criticism of or request for clarification of its guidelines from any doctor or representative body regarding the practice of obstetrics. There have been no prosecutions of doctors. Now, I have no doubt that those fears are sincerely held by some doctors and that we must address this perception. But the real question is, are these fears well-founded? Obstetricians are not lawyers. Perhaps they do not appreciate the mental element required to prove a crime. A jury must be convinced beyond reasonable doubt that a doctor has acted deliberately, intending to carry out an unlawful abortion. The doctor who acts in good faith, ethically, with due care, and in a manner which another doctor of similar expertise might be expected to act in a similar circumstance, has nothing to fear from the law. Doctors make judgments all the time. They won't always be right, but that is not negligent, and it is certainly not criminal. The European Court decision of ABC recognised that Ireland may make whatever policy it chooses regarding abortion and the right to life. It doesn't require us to legislate for X. It gives no direction regarding the content or form of action we take. It requires that we have accessible procedures by which people can know the law and know where they stand, and that is entirely reasonable, and justice demands it. Legislating in this area would not be problematic were it not for the X decision itself, and here we come to the nub of it. The court heard no medical evidence. There was no psychiatric evidence. There was no duty of care to the unborn. Chief Justice Finlay considered that suicidality in pregnancy could only be avoided by abortion, against his test, and that abortion could not be postponed in order to monitor the woman's condition, unlike the case for physical risks to the woman's life. But perinatal psychiatrist John Sheehan has told this committee that psychiatric intervention is exactly the opposite to medical intervention, and that the notion of carrying out an emergency termination is completely obsolete, I'm quoting him, completely obsolete in respect of a person who is suicidal. So after this week, we know that abortion will never address the suicidal woman's actual needs, and it might very well harm her. It is therefore unthinkable that we should legislate for abortion to address suicidality. Ultimately, a referendum will be required to deal with the difficulties posed by the X case. In the meantime, we propose that the Medical Council should draw up guidelines to deal specifically with the issues surrounding medical interventions for physical complications of pregnancy. The government should give a commitment to the Committee of Ministers of the Council of Europe that guidelines will be drawn up by the appropriate bodies of medical expertise within the medical profession, based on medical practice, addressing ABC case, giving the clarity that's required. The government should give a commitment that the difficulties associated with X will be examined, the options for clarifying them identified, and that the government will keep the committee informed of progress. The Committee of Ministers has acknowledged a significant increase in the number of cases relating to complex and sensitive issues which need more time to resolve. This issue is indeed complex and it is certainly sensitive, but this committee's efforts over the last few days have clarified much of what was confused. For this, we owe you our thanks. Now that they are clearly identified, we may finally address the problems posed by the X case and ensure that every woman in Ireland can be confident of the continued highest standard of maternal and fetal care. Thank you.
Thank you, Ms. Sims. Thank you very much indeed. And sorry for the interruption with the microphones. My
That's
apologies.
quite all right.
If you want to play, swap the seat again, if you want to, I think Mr. DeFrida maybe might be going to do that. And to your credit, you're one of the few witnesses and members who've adhered to the time limit, so thank you for that. I want to welcome now from Youth Defence, Mr. Dr. Owen DeFrida. Dr. DeFrida, you have 7 minutes.
Okay,
Up to 7 minutes.
Thank you. I'm just going to share my time with Dr. Sean O'Donnell of the Life Institute. Good afternoon, ladies and gentlemen. My name is Dr. Owen DeFrida. I'm a medical doctor and I'm a member of Youth Defence Pro-Life Group. I've been involved in pro-life activities, I guess, since my late teens, and I want to thank everyone for the opportunity to invite me here today to address you on this current debate. I firstly wanted to refer to the 2010 decision of the European Court of Human Rights in the ABC versus Ireland case, which is largely the reason we all find ourselves in this room today. Contrary, I think, to the many media reports and some statements made by government officials and others on the ruling, the ECHR absolutely did not demand or even require that Ireland legislate for abortion. In fact, no legal right to abortion exists in the European Convention. Instead, the court asked that Ireland provide clarity, which can, of course, be provided without legislating for the X case. The second point I'd like to make is in relation to abortion and maternal health care, which I believe really is the crux of this issue. It goes without saying that Ireland is a world leader when it comes to maternal health. Our excellent track record and high standards of maternal health care, coupled with our extremely low rates of maternal mortality, are second to none. We have achieved such high standards to date without legalised abortion. And that's because Irish obstetricians and other specialists will always intervene to save the life of a mother when she has a life-threatening complication of pregnancy. This practice of intervening, which includes premature delivery of the baby, even when the baby has little or no chance of surviving, is permitted in Ireland today. It's permitted under Irish law, under the Medical Council's ethical guidelines, and within pro-life principles. As a medical practitioner, I believe that the Medical Council's guidelines, the current guidelines, are crystal clear when it comes to intervening in pregnancy when a woman's life is at risk. And I would like to echo Professor Fionnuala McAuliffe's recent comments when she said that obstetricians know that they have absolute freedom to intervene to save the life of a woman, even if it meant the loss of life of her unborn baby. And this brings us to a crucial distinction which was clarified during the hearings before this committee on Tuesday, but it is all too often misunderstood. And that is the distinction between the termination of pregnancy and the termination of the life of a child. Irish doctors have such freedom to intervene under current Medical Council guidelines because there is a clear difference between intervening to save a woman's life, which includes premature delivery of the baby, and abortion, which intentionally destroys the life of an unborn child. The blurring of this distinction between these two practices is what is contributing mostly to public confusion today. Birth is a termination of pregnancy. An emergency caesarean section is a termination of pregnancy. Premature induction of labour is a termination of pregnancy. And thanks to the expertise of our obstetricians and neonatologists, many of these premature babies survive. How can these be described as an abortion?
You're halfway through your sharing time.
The questions asked by Senator John Crown directly addressed this distinction during the hearings on Tuesday. Senator Crown asked if it is necessary in permitting a life-saving termination of pregnancy to kill the fetus in utero, or can the pregnancy be delivered to give the life-saving treatment the woman needs? The Master of the National Maternity Hospital responded by saying, "We never kill a fetus. That is not our aim. Occasionally it is required that in pregnancy, before the baby is viable or capable of surviving in our neonatal intensive care unit. When there is any possibility at all we can preserve the life of the baby, we will do so. We are able to do so from a very low gestations, from 23 weeks on. In those cases, members can be very certain that we will make every effort to preserve life." It was also established that there were no known instances where a mother had needlessly lost her life because of any supposed lack of clarity in the legal framework. Thirdly, and briefly, I would like to address the claims so very often made by pro-abortion campaigners that women need to leave Ireland in order to access so-called life-saving abortions in the UK or elsewhere. I know that many of my medical colleagues find it grossly insulting to their profession to suggest that we are somehow risking women's lives by not permitting abortion in Ireland. Almost always, these claims are made without any foundation or without any fact. Figures freely available under Freedom of Information from the Department of Health show these claims to be entirely false. The most recent data from the Department of Health for the years 1992 to 2010 inclusive clearly show that there were 0 abortions carried out on Irish women in Britain under Category F of the Abortion Act, which records abortions carried out to save the life of the mother. Furthermore, there were 0 abortions carried out on Irish women in Britain during the same period under Category G, which records abortions carried out, and quote, to prevent grave permanent injury to the physical or mental health of the mother. And that number is 0 because Irish women are never denied care, life-saving care, that they need during pregnancy. A review of this evidence, easily undertaken, has therefore revealed that Irish women are not travelling to the UK to undergo so-called life-saving abortions because they are being denied treatment in Ireland. The truth remains that Irish women are safe in Ireland and are receiving today whatever life-saving treatments they need.
Mr. Mann.
I'd like to hand over to my colleague, Dr. Sean O'Donnell. Thanks so much.
Okay. Ladies and gentlemen of the Health Committee and members of the public and public representatives, I'm a consultant in general adult psychiatry, working in the public, independent and voluntary sectors where I deal with the broadest possible case mix. I've also worked as a consultation liaison psychiatrist with particular responsibility for perinatal psychiatry in Ireland for over 2 of the last 3 years. I began my career in psychiatry in Jersey in 1997, 1 month before the legalisation of abortion on that island. My very first assessment of an attempted suicide victim was on my very first weekend on call in Jersey, when I was asked to review a 19-year-old girl who had taken a large overdose of medication. During the course of that assessment, when I asked her why it was that she had sought this ending to her life, she indicated to me that she had been pressured some 6 months earlier by her parents and by her boyfriend to undergo a termination of pregnancy. Because abortion wasn't legal in Jersey at that time, she was forced to travel to Southampton, where she had the abortion against her will. 6 months later, she had descended into a profound depression and attempted to end her life as a result. At the time of that assessment, and I remember it clearly, she said to me, as I tried to discuss with her how she would recover from this depression she was suffering, she turned to me and she said, "Can you tell me that I haven't killed my own baby? Can you tell me that I can undo what I've done? Can you tell me how to bring my baby back?" I hope today I'm in a better position to answer those questions which are asked of me on a frequent basis. But of course, in my day-to-day work, I come across women on a frequent basis who find themselves in situations that they describe as crisis pregnancies or unplanned pregnancies. And indeed, over the past 12 months alone, I can refer to a case of a lady who 22 years previously underwent an abortion, and for that following 22 years, for a period of approximately 3 weeks around the anniversary of the abortion, her husband reported that she suffered with very marked depressive mood. I've also experienced a situation where a 21-year-old girl presented for treatment of post-traumatic stress disorder, having had an abortion at the advice of her mother and her aunt some 7 years earlier. And I think that these people are being left out of the have been left out of the hearings to a large extent. According to the major textbook of psychiatry, edited by Professor Basant Puri, I quote from the third edition of that book, Revision Notes in Psychiatry, and here's the quote: "Only 10% of women suffer with severe and/or prolonged sequelae as a result of induced abortion." And
thank you.
I think the word "only" there shows us what opinion is being taken and what approach is taken towards these women who suffer as a result. That means a figure of approximately 19,000 women in Britain, and in this country at present somewhere in the region of 400 women per year.
Thank you very much.
Thank you.
Thank you. And I want to welcome Mr. David Manley from Family Life. Mr. Manley, you've got 7 minutes. Thank you.
Thank you, Mr. Chairman. On behalf of Family and Life, I'd like to thank the committee for the opportunity to address it today and to allow us to contribute to its deliberations. I hope that I and my colleague, Mr. Patrick Carr, will be helpful to you. What follows is a much shortened version of the written opening statement, which has already been circulated. Now, the issue of abortion is characterized as being divisive, and indeed it is. There is, however, a large area of agreement and common ground. Everyone, I assume, is in agreement that the women in Ireland should receive whatever medical care they require in pregnancy. And at the same time, there is a large majority of Irish people who would like to see the protection of unborn human life continue. Provided that people are reassured that such protection will not have any weakening effect on medical care provided to pregnant women, all but a small number are content to see the comprehensive prohibition of abortion in Ireland. And I'm using the word abortion in the commonly understood sense, and I'm aware of the confusion that surrounds this word. In the 2010 case of ABC versus Ireland, the European Court of Human Rights did not require Ireland to legalise abortion. The court required the government to put in place procedures that are effective and accessible for women. It made no stipulation as to what the legal status of these procedures should be. Following the decision of the European Court in that case, the government established an expert group to lay out the options available to it. Unfortunately, and for reasons not altogether clear, the expert group's remit was restricted to giving advice, and I quote, on how to give effect to existing constitutional provisions, end of quote. In other words, it limited itself to options giving effect to the Constitution and the X case judgment. The 1992 judgment of the Supreme Court in the X case is, and I believe will remain, the source of our current legal difficulty and social controversy until such time as its suicide provision is removed. The European Court of Human Rights judgment only requires Ireland to address the perceived lack of clarity in its law on abortion. In reality, the clarity which the court requires can be provided without enshrining in statute law a principle that allows for the direct and intentional killing of an innocent human being. In other words, of the suicide provision. And I depend very much, I think, on Professor William Binch's testimony yesterday. It is clear from the testimony given by prominent obstetricians who have come before this committee that further clarity is desirable indeed. But it is important to note that whatever lack of clarity presently exists and existed, it clearly did not prevent doctors in Ireland from providing women in pregnancy with a high standard of medical care that they need. It is regrettable, I believe, that the government has prematurely committed itself to a course of action without the benefit of the valuable testimony that has been presented to this committee over the recent days, and indeed to the work of this committee. This is particularly so since the course of action chosen involves legislation giving statutory effect to the suicide provision of the X case. All the psychiatrists who testified before this committee agreed that abortion is not a treatment for suicidality, and predicting who will take their lives is not a workable project. The idea that that lives of some human beings are less valuable than those of others has no place in Irish law. The Irish Constitution recognises the fundamental equality of all human beings. To their abiding credit, at a time when so many other countries were moving in the opposite direction, the Irish people in 1983 made explicit that this equality extends to the most vulnerable of human beings, the unborn. The Irish people's decision was based, as the European Court of Human Rights recognized, and again I quote, on profound moral values concerning the nature of life, which have not been demonstrated to have relevantly changed since then. Now I believe there are some promises that should not be broken, and that the government has no mandate to legislate for direct and intentional killing of unborn children. To do so would be to make a law that would be fundamentally unjust, violating the most basic of human rights. Thank you.
Thank you very much, Mr. Manley. And finally, I want to welcome Ms. Breda O'Brien from the Owen Institute. I think who's going to speak. You have 7 minutes. Thank you.
As a woman whose primary qualification to be here is as a woman, a mother and a teacher, I'm particularly grateful for the opportunity to interact with TDs and senators at such an important time as this.
Sure, Ms. O'Brien. Okay, that's fine. Thank you.
And thank you very much for that. I've spent nearly 3 decades teaching young women who are the primary group that are going to be affected by any decisions that you make. And in that time, I've witnessed something terrifying, which you have also witnessed, which is the normalizing of suicide, that it becomes part of a menu of options as a response to extreme stress. And like many of you, my own family has been touched by suicide. So when a girl comes to me in school and whispers, "I don't think I can go on much longer," I take it very, very seriously. I move immediately to put a circle of care around her, beginning with her parents. People have expressed concerns that if we exclude suicide as a grounds for abortion, that we're somehow stigmatizing mental illness. In fact, the grave mistake would be to fail to see that there is a difference. Doctor after doctor has told us that they never fail to intervene where there is a life-threatening risk to a mother. But someone far more qualified than I, perinatal psychiatrist Dr. John Sheehan, has said that in the case of suicidal threat, the notion of carrying out an emergency termination is completely obsolete. A better, a calmer intervention is needed. So, suicide is different. And if we're going to enact just and safe legislation, it has to be treated differently. The judges in the X case acted in good faith in deciding what they did. The tragic consequences for Miss C, the first girl after X to whom the test was applied, were a direct result. Miss C had been brutally raped at 13. Unlike Miss X, Miss C was psychiatrically assessed and taken to England by the state for termination. The consequences were disastrous. She has never gotten over the loss of the baby and has made numerous suicide attempts since. Thankfully, none of them have been successful. If we want to trust women, we have to trust the experience of women like Miss C. The Department of Education has strict guidelines against doing anything that normalizes suicide as a response to stress. Journalists would be excoriated if they described a single or a simple cause to suicide because of the danger of so-called copycat suicide or contagion. And yet, by legislating for suicide, crisis pregnancy is being presented, even in very rare circumstances, as something so awful that suicidal thoughts and threats are an acceptable reaction. Anyone with a bit of life experience will tell you, it isn't the baby that ruins your life. It's everybody else. It's the family who won't stand by you, the principal who won't give you a place in his school, The partner who'll pay for an abortion but won't pay child support. That's what ruins your life. And it's those kind of attitudes we should be starting to act against, not the innocent baby growing in the womb. If we legislate on the grounds of abortion, we're doing something seismic. We're saying, within a year of enshrining the best interests of the child into the Constitution, something I voted for, within a year, we're saying that it's acceptable to end the life of a child because her mother is in distress. How can that be in a child's best interests? No one, but no one, objects to life-saving treatment for a pregnant woman. But we mourn and we sympathise with the family that loses a baby as a result, even though we rejoice that the mother is still with us. In the expert report, it refers to delivering children on the fringes of viability. In the case of suicide, the perinatal psychiatrists say there is never an emergency where an immediate abortion is necessary. So you're asking an obstetrical team to scrub up some morning and deliberately induce labour and deliberately deliver an extremely premature baby. That premature baby will be at risk of brain damage, blindness, and even death. In the case of life-threatening illness in the mother, saving the child would be a triumph no matter what the challenges. But think of the devastating consequences for the child in the case of psychiatric illness. And all of this is in the absence of benefit, of any evidence of benefit to the mother. And I'm going to quote Planned Parenthood, which is the biggest single abortion provider in the United States. A woman with an unwanted pregnancy is as likely to have mental health problems from abortion as she is from giving birth. A woman with a history of mental health problems before abortion is more likely to have mental health problems after abortion. We're being told that in the case of wanting to die by suicide because you're pregnant, that abortion is not treatment, but as part of a package, it just might be appropriate medical care.
2 minutes remaining.
Something that might just help does not meet the test set out in the expert group report. A real and substantial risk that can only be avoided by a termination of the pregnancy. No one that you've heard from any viewpoint has even gone near suggesting that an abortion meets the criteria of being the only way of preventing suicide. Something that just might be appropriate medical care is a very shaky foundation on which to build legislation. Martin Luther King in his jail in Birmingham said, there are just and unjust laws. You have a moral and a legal duty to follow just laws. You have a moral duty, responsibility to disobey unjust laws. Legislating on the grounds of suicide would be both unsafe and unjust. Thank you.
Thank you very much, Ms. Sims. Mr. Bryan, sorry, my apologies. Thank you. There now follows 60 minutes of questions and answers from the members. I call on Deputy Billy Keller.
Thanks very much, Chair, and just to welcome the witnesses. I suppose it's addressed to all witnesses who have made presentations, but it comes from the Pro-Life campaign submission in the context of a survey of the maternal deaths in the three Dublin maternity hospitals, Rotunda, Holles Street and the Coombe, from 1980 to 2011 found 2 maternal deaths by suicide out of a total of 680,000 live births, and both occurred after delivery ex partum. Just in that particular time frame as well, there would have been about 130,000 women who would have travelled to England or other countries outside of this jurisdiction for a termination or an abortion. I'm just asking the question, is it possible, because the vast majority of people who would have travelled would have possibly been in a crisis pregnancy situation, that they may have been people, if they weren't able to access, I'm only posing the question, that if they weren't able to access a termination, may have fallen into the category of being suicidal if they weren't able to access information. You'll be able to answer the question.
We'll take the questions in groups.
It's just a question I pose, because there does seem to be a view that somehow there's no statistics or figures available to us to assess the 130,000 women who have travelled abroad for the terminations over that intervening period as well. I'd just like some clarity on that particular issue. On the broader issue, when you speak about the fact that you're concerned about suicide opening up to a more liberal abortion regime, are you effectively saying that there should be a referendum to roll back on the interpretation of the X case of Article 43.3? Or what are you saying is the solution from your perspective in terms of addressing the outstanding issue whereby the Supreme Court hasn't made the interpretation. Some of you will say that was based on flawed assessments, no psychiatric experts brought into play or whatever. But the point is, it is, as it stands in jurisprudence, the law. And the only way to address that particular issue, from your point of view or perspective, would be, are you calling for a referendum?
Thank you. Sorry. No point of order, no.
With just to assist the committee.
No, thank you. No point of order.
I just noticed some. I was just wondering whether Ms. Dean was meant to be given the opportunity to present.
As you know,
Dr. Mullen spoke about hospitality this morning. I thought.
As you know from during the week, Senator Mullen, each group is given allocated time. And
I just thought I saw some confusion between you.
Just to clarify, Senator Mullen, just so that you know, the opening time limit was 7 minutes per group, and I, in fact, exceeded that. I was generous with some of the, given what happened with the microphone with Ms. Sims, and the chair is fair to all members and to
Thank
all
you for that
witnesses.
clarification. I think you possibly would agree with me. It would be appropriate and generous if there was an opportunity given to a guest in due course.
As you're aware from the proceedings during the week, Senator Mullen, witnesses, be it in groups of 1 or 2, will be able to participate, and the chair is fair.
I trust your good judgment and hospitality.
It's not my judgment, Senator. The committee have decided in their own rules and regulations for the hearings for the last 3 days how to conduct itself.
I think the point is understood in all sides.
Senator, or Deputy O'Quillan, my apologies.
Well, I'd like to join with you, Cahill, in welcoming each of our guests here today and to thank them for the respective contributions. Ms. Simmons, just at the outset, you used the phraseology in relation to the government completely demolished. I felt like punching the air and saying, hurrah! I wish. In any event, here we are addressing a very important issue here today, and there's very limited opportunity for us as legislators to question. So I just want to try and make a couple of points, and I'd like to ask in relation to Sean O'Donnell. Sean, I note you're a consultant psychiatrist, and I had posed the question earlier today, and I think yesterday too, that we're advised that the guidelines for medical practitioners states, and it does, we've had the opportunity to examine it, state that under current law, it's case law certainly, but under current law in this state, where a woman's life is at risk, an intervention is permissible, and that includes, as it states, in the Medical Council guidelines, the situation regarding suicidal intent as against suicidal thought or consideration. Now, in your experience, and you've shared that with us in the course of your contribution and in your contribution in writing, what I'd like to ask you is, if that has been the case, and we had 5 very experienced consultant psychiatrists before us on Tuesday of this week, and despite the fact that that is the current guidelines of the Medical Council, they each confirmed that never in their experience had they ever to employ such an intervention. Why is it that if it is the case already, and what we're advised by government is an intention to bring in confirmatory legislation, that we would expect the situation to change? I just ask your consideration of that. And if I could just make 2 last quick points. I'd like to just, if I could, Ms. O'Brien from the ONA Institute, I want to welcome your identification of some of the forces and attitudes in society that clearly have driven some women, including some very young women, to seek an abortion. And those attitudes, in my opinion, must be confronted by all, irrespective of our respective attitudes or outlooks on the core issue being addressed here today. And my last point is to Mr. Manley. You do acknowledge in a substantial written submission that today 1 in 19 Irish pregnancies ends in abortion, albeit on the neighbouring island. But you also indicate that what you believe is required is a further referendum. Would you elaborate on that? Because that was a view already expressed by some voices from